There are lots of good reasons to do mediation, and I've come up with what I'm going to call my top 5 reasons for doing it. I don't know if this particular order is scientific or not, or just sort of my best guess, but I'll give what I view as being 5 really good reasons uh, why I have come to believe that mediation is something that has to be tried in every case where there isn't an easy and fast resolution achieved first. And reason number 1 is a really simple one. It's not litigation. I've litigated a whole bunch of cases in my time. I've been practicing in this area for over 30 years. I started when I was 4 years old, by the way. And I've tried, in of the cases I've tried, I think I've gotten pretty good results. If there was a win-loss record, I think I've won more than my share. But in each of those cases, I felt that the costs were extraordinary, and I thought that the resultant harm to the parties was quite unfortunate, especially if there are children. You know, the lawyers try the case, advocate for their client. Sometimes you're fighting for your client, and then we hopefully get paid, go away and tell the client spend the next 30 or 40 years of your life co-parenting these children. And it doesn't matter if the children are minors or adults. It's the same issue, same problem that applies, that they have to live with each other. As a result, I've come to believe that the litigation system, at least in this field, maybe others as well, but the field that I practice in, is one that should only be used as absolute last resort and before taking client to trial. I will always try to get the other side to agree to mediation, and as is clear by the change in the Family Law Update Program starting in 2020, I'm also serving as a mediator in more and more cases and trying to resolve cases peacefully. So reason number 1, as simple as it sounds, is it's not litigation, and anything that's settlement oriented, that is not fighting, is a good thing. My number 2 reason is the one that most parties put as their number 1 reason, which is cost. Mediation is not necessarily an inexpensive system. When there are 2 lawyers involved, generally we do caucus mediation. In other words, one lawyer in the parties in one room, the other lawyer in the parties in the other room, mediator goes back and forth. The result of that is a lot of downtime for whoever the mediator is not meeting with at that particular period of time. Even so, it's a lot less expensive than litigation. And even where mediation has not succeeded in terms of finishing the mediation session and having a complete agreement, generally, I'm going to use the term generally, but I probably could use the term always, one of 2 things is true. Either it sets the stage for resolution by getting the parties to a point where they can finish it off on their own, or in the rare instance where it has not and the case still goes to trial, it makes the trial easier because the parties have narrowed the issues, understand the other side's position, and can address it, and it makes the trial generally more efficient. So mediation, and again, I'm going to qualify it by saying almost always, but I could probably be brave and say always is less expensive than the litigation process, and the savings of cost is a significant reason why mediation should be tried in every case. Number 3 is the rate of success. I've had several occasions where my clients were reluctant to do mediation because they say we're wasting time and money. There's no way we can settle this. We've already tried to settle it. I know my spouse. There's no way they're going to agree to anything reasonable. And I even remember one case where the morning of the mediation, my client called me to cancel it. We're just wasting time and money. And we walked out after a few hours with a complete and total agreement. It has an interesting rate of success. At some point during the process of developing FLU and developing videos and writing about mediation, I'm going to explore more about why it's successful and why it works. But the point is it usually does. And that's in cases that seem intractable, seem unsettlable. I don't know if that's a word, but it is now. And cases that everyone thought are going to be headed to trial. It has an incredibly high rate of success in, at the minimum, getting to the parties to a position where they'll be able to settle it between themselves in the near future, and a fairly high rate of success at resolving it at the end of the mediation process itself. Fourth reason is it impresses on the parties a concept of compromise. Compromise means you're not going to get everything you want, and in divorce, nobody ever gets everything they want. And the question comes is, what do you give up, and who decides what you give up? And parties who accept the concept that I want to make the decision of what I give up so that I can choose the things that are of lesser importance to me, learn a good, I think, life skill, because I think life is a series of compromises and a methodology of resolving conflicts. And some of that may actually carry over to other things in their lives as well. But certainly the mediation process deals with this concept of, okay, you're not going to get everything. Let's decide what you're willing to give up, what would be fair and reasonable and in your best interest to give up to get to this place where, as Fisher and Urey said in their famous book, getting to yes. And number 5 is settlement in general, and mediation as part of the settlement process sets a template for future resolution of issues. I read a study a number of years ago that cases that settle in mediation have a far lower recidivism rate, meaning they're far less likely to be involved in litigation than cases that had been litigated. I question a little bit that study, because it would seem to me that people who settle the case are people who, in most cases, wanted to settle it, wanted to work to settlement, that the issues were probably easier to settle, why parties that had litigated, that none of that was true. In other words, there was probably a reason why the case settled originally, and probably a reason why the other cases didn't. So no wonder there was a higher rate of settlement in future issues and lower rate in the others. But it seems to me to make sense, though, that when people make compromises and understand that the other side made compromises, that in the event there are issues again in the future, which in most human relationships is more likely than unlikely, that it helps to have a history where the issues were resolved. And mediation being a back and forth, let's discuss this, let's talk about this, let's see where we can reach some agreement someplace in between everybody's maximalist position, sets a template not only in terms of compromise, but also in terms of that we've resolved issues in the past, let's keep resolving them in the future. So in an upcoming video, I'm going to give 5 pitfalls to mediation. Everything that has a good side has to have a bad side as well, and we'll examine that in a future video.